Good evening. Thank you for hopping on with us. Give me a moment, please, while I share this to my personal page, if Facebook cooperates this time. And if not, then I will just share it later. Okay, here we go. Share. Okay, so thank you very much for hopping on. So my name is Candace Washington, owner of Joy Lasan Consultancy, and we help our clients to protect their assets without breaking the bank. So if you've followed us for any length of time, if you followed me, you know that I'm really passionate about estate planning and making sure that we have the proper legal documents in place to pass on our assets to future generations. And one thing that's really popular these days is everyone is talking about generational wealth, but in the African American community specifically, we are very behind on the generational wealth bandwagon. And that's like a buzzword now. Everybody's talking about it, but we're not really taking the steps that we need to make sure that we're passing that wealth and our assets onto future generations. And the way that we do that is by putting it in writing in a legally solid document called a will or a trust. And so someone asked me today, what's the difference between a will and a trust? And so I just wanted to take a few moments to talk about the difference between a will and a trust. So a will states how you want your affairs to be handled and your assets to be distributed upon your death. If you have minor children, it also appoints a guardian for those minor children so that your family won't have to go through the probate process or go to probate court and have to deal with a judge determining who is going to be guardian over your children. And that could end up being someone that you would never have chosen to be the guardian for your children. And so that's why it's important to have a will in place. Your will can also be used to disinherit people. And so if you have children that you don't want to receive anything from your estate, you can actually disinherit people in your will. In some states, if you have in some states, you can actually disinherit your spouse as well, but those laws change by state, and so we definitely encourage you to speak to an attorney about the laws in your state when it comes to disinheriting people through your will. All wills must go through probate, and that takes time. And so just having a will doesn't eliminate your estate going through probate. And so when you pass, having a will makes the probate process much easier and a little bit shorter, but it still has to go through that process. Also, in your will, your estate, all of your assets and everything that you have in your will, that becomes a matter of public record. And so those are like the high points of a will. A trust, however, is when you give another party the authority to handle your assets for the benefit of a third party. So let's say you determine who you want to manage your trust on behalf of your beneficiary. So a lot of people have their children as their beneficiary. There are many types of trusts, but a living trust and a testamentary are the two most common types. A testamentary is like your will. A living trust is called a living trust because it's created while the trustor or while you are alive. It is revocable, and it also can be changed at any point during the life of the trustor. So while you're living, you can change your trust as many times as you need to. It also only becomes operational, or it only takes effect at your death, just like a will only takes effect when you pass away. Unlike the will, in your trust, your property passes and your assets pass without having to go through the probate process. And so it can be passed immediately to your beneficiary. So there's no delay in whatever you're leaving for your beneficiaries. There's no delay for them receiving what you have left to them. And it also stays private. So it doesn't go on public record like with your will. Your trust must be actively managed, and so for that reason, it usually is a little bit more expensive to get a trust done. And I say it has to be actively managed because it's of no use unless it's funded. So you can have a trust and sorry, doorbell threw me off. You can have a trust, but if you don't designate the assets to be applied to that trust and keep that current, then the trust is of no use. So you can set up a trust today, and if you go and you buy a new house, next year, or you buy more property, or you get more assets in the stock market, and you don't add those to the trust, then the trust doesn't have its full value. Another thing about trust is that it can reduce the estate tax that your heirs have to pay on what you leave behind, and it can also provide protection from creditors. One big thing that a lot of people use trust for is for their children or their beneficiaries. And so with a will, if you pass away and your children are minors, whatever you leave to them in your will, they get all of that when they turn 18. With a trust, you're able to designate what you want to pass to them when they turn 18 and subsequently. So if you leave $100,000 for your children, for each child, you can designate, $10,000 to each child when they turn 18 for, $10,000 per year. So they don't get that full sum of $100,000 when they turn 18. So it's a little bit more manageable that way when you pass along your assets that way to children who, would be young. Anybody coming into $100,000, I know some adults that could come into $100,000 and would blow right through it because they don't know how to manage it properly. So those are just some high level differences between wills and trusts. Always recommend that you speak to an attorney about your specific situation and setting up the proper documents based on your specific situation. Please feel free to work with us and schedule a call. You can book a complimentary consult at bit.ly/covermyassets. We're happy to talk to you about this process more and how we can help you get all of your estate planning documents prepared. Thanks so much for hopping on, and I'll see you next time.